Question 526. All of the following would be considered a capital asset, except A. Inventory, B. Structures, C. Land, D. Factory machinery. Correct answer is A. Inventory. In tax law, capital assets are generally defined as property held for investment or personal use. They are not assets held for sale to customers in the ordinary course of business. Inventory refers to goods held for sale to customers in the regular course of a business. Therefore, it is specifically excluded from the definition of a capital asset. Structures, like buildings, are typically considered capital assets, especially if held for investment, e.g., rental properties, or used in a business, though depreciation rules might apply differently. Land held for investment or personal use is a classic example of a capital asset. Factory machinery. Machinery used in a business is generally considered a capital asset, although it is subject to depreciation. Therefore, inventory is the exception because it is held for sale in the ordinary course of business, not for investment or personal use. Question 527. Writing, for deposit only, on the back of a check creates A. Blank endorsement, B. Qualified endorsement, C. Signed endorsement, D. It has no legal effect. Correct answer is B. Qualified endorsement. A blank endorsement consists only of the endorser's signature. It makes the check payable to bearer, meaning anyone in possession of the check can cash it. For deposit only adds a restriction, so it's not a blank endorsement. While a qualified endorsement includes a signature, the term signed endorsement is too general. All types of endorsements require a signature. The key difference is the additional wording that modifies the purpose or liability of the endorsement. Writing, for deposit only, has a significant legal effect. It instructs the bank on how to handle the funds and limits the further negotiability of the check, providing a level of security for the endorser. A qualified endorsement limits the endorser's liability. By adding the restrictive phrase, for deposit only, the endorser, the person or entity to whom the check is payable, is instructing the bank to deposit the funds into a specific account. This limits the negotiability of the check and protects the endorser if the check is subsequently lost or stolen. It ensures the funds go directly into the intended account. Question 528. If a caller refuses to give their name at the beginning of a phone inquiry, the appropriate response by an agent is to A. Hang up the phone and move on to the next call, B. Interject useful information to keep the conversation going, C. Pass the call to someone else in the office, D. Keep asking the caller for his name throughout the phone call. Correct answer is B. Interject useful information to keep the conversation going. Giving up on the phone call, even if a caller does not want to provide his name for whatever reason, should run counter to the agent's training and instincts. The agent should try to maintain the possibility of forging a connection beneficial to both himself and the future client. The goal of handling an inquiry is to be helpful. By providing relevant information related to the likely reason for their call, the agent can demonstrate value and build trust. The caller might feel more comfortable sharing their name once they see the agent is knowledgeable and can assist them. Focusing on the substance of the inquiry first can often lead to the caller feeling more at ease and eventually providing their name if necessary for further assistance. Hang up the phone and move on to the next call is unprofessional and provides poor customer service. While identifying the caller might be ideal, immediately terminating the call because they haven't given their name prevents the agent from understanding and potentially addressing their needs. Randomly passing the call is unlikely to resolve the situation, unless there's a specific protocol to handle anonymous inquiries by transferring them to a specialized department. The next agent will likely face the same initial refusal. Repeatedly demanding the caller's name after they've indicated they don't want to provide it can be confrontational and make them even more reluctant to engage. It prioritizes identification over addressing the reason for their call. Question 529. A personal easement in gross. A. Benefits a person, not the land. B. Creates no dominant tenement, just a servient tenement. C. May not be assigned to a third party. D. All of the above. Correct answer is D. All of the above. A personal easement in gross is a type of legal right that allows an individual to use someone else's property for a specific purpose, but it's not connected to any specific piece of land the beneficiary owns. Unlike an easement appurtenant, which benefits a specific parcel of land, the dominant tenement. Since the benefit is tied to a person and not a specific piece of land, there is no dominant tenement, the land benefited by the easement. There is only the servient tenement, which is the land burdened by the easement. Personal easements in gross are considered personal rights and are not transferable or assignable to another person unless the specific terms of the easement explicitly allow for assignment. This is because the easement is often granted based on a personal relationship or a specific need of the original grantee. A neighbor may have a personal easement in gross to cross your property to access a fishing spot on the lake behind your house. A utility company might have a personal easement in gross to access and maintain power lines that run across your property. Question 530. The Uniform Commercial Code, Division 6, which pertains to bulk sale transfer of business goods, is designed to protect A. Creditors, B. Sellers, C. Buyers, D. The IRS. Correct answer is A. Creditors. When a business sells a substantial portion of its inventory or equipment, a bulk sale, outside the ordinary course of business, there's a risk that the seller will take the proceeds and disappear without paying their outstanding debts. UCC Division 6 aims to prevent this by providing a mechanism for the seller's creditors to be notified of the impending sale and to assert their claims against the proceeds. Here's how it generally works. Though specific provisions can vary by jurisdiction, and many states have repealed Article 6. 1. Notice to creditors. The seller is typically required to provide a list of their creditors to the buyer, and the buyer must notify these creditors of the bulk sale before it takes place. 2. Application of proceeds. In some versions of Article 6, there are provisions for the proceeds of the sale to be applied to the seller's debts to their creditors. While the UCC generally aims for fairness in commercial transactions, the specific focus of Division 6 regarding bulk sales is to safeguard the interests of those who have extended credit to the seller. As mentioned, many states have repealed Article 6 of the UCC, finding it outdated or creating unnecessary burdens on businesses. In jurisdictions that still have it, the specific requirements can vary. However, the fundamental goal of creditor protection remains central to its original intent. Question 531. Although not authorized to do so, Agent Andrew acts on behalf of seller Stan by showing Stan's home to a potential buyer. Later, after the buyer makes an offer, Stan approves of Andrew's action. This is an example of A. Rescission, B. Ratification, C. Implication, D. Covering up. Correct answer is B. Ratification. Rescission is the cancellation or termination of a contract, as if it never existed. This is not what happened here. Stan approved the action that led to the offer. Implication can refer to authority that is reasonably assumed based on the agent's position or past actions, but in this case, Andrew was explicitly not authorized initially. Ratification is the specific term for subsequent approval of unauthorized actions. Covering up implies concealing wrongdoing, which is not the scenario described. Stan openly approved Andrew's action. Ratification occurs when a principal, seller Stan, approves or accepts an act that was performed on their behalf by an agent, Agent Andrew, who did not have the authority to do so at the time the act was performed. By approving Andrew's unauthorized showing of the home after the fact, Stan is retroactively granting Andrew the authority for that action. By approving Andrew's unauthorized showing of the home after the fact, Stan is retroactively granting Andrew the authority for that action. Question 532. Jody leases a property from Sandy. Although Sandy takes Jody for a tour of the property, Sandy does not mention that a large sinkhole is located at the end of the lawn, which Sandy has covered up with a tarp but not filled in. A month later, Jody's friend Jamie is visiting the property and falls into the sinkhole, breaking his arm. When Jamie sues Sandy for negligence, Jamie will probably A. lose, because Jamie should have known that piece of land covered by a tarp represented a danger. B. lose, because Sandy owed a duty to warn Jody, the lessee, but did not owe it to a visitor. C. win, because Jamie was owed a duty to warn from Sandy. D. lose, because a month had passed since the lease commenced. Correct answer is C. win, because Jamie was owed a duty to warn from Sandy. Landlords generally have a duty to warn tenants of latent, hidden, defects or dangerous conditions on the property that the landlord knows or should have known about and which are not obvious to the tenant. Sandy actively concealed the sinkhole with a tarp, indicating knowledge of the dangerous condition and an intent to hide it. It is foreseeable that a tenant would have guests visit the property. Therefore, Sandy's duty to warn Jody extends to Jody's invitees like Jamie. While a tarp might suggest something is underneath, it doesn't necessarily scream, hidden, dangerous sinkhole. The law generally doesn't expect guests to anticipate deliberately concealed hazards. The duty to warn falls on the landowner who knows of the danger. Question 533. An exculpatory clause will not insulate a broker from liability to the purchaser if it is A. not approved by a judge, B. not endorsed by a contract attorney, C. against public policy, D. regarding a property that is worth less than $1 million. Correct answer is C. against public policy. An exculpatory clause is a provision in a contract that attempts to relieve one party, in this case, the broker, from liability for their own negligence or wrongful acts. While such clauses can sometimes be enforceable, they are generally not enforced if they are deemed to be against public policy. Courts often find exculpatory clauses against public policy in situations where 1. There is a significant disparity in bargaining power between the parties. 2. The service being provided is essential to the public. 3. The party seeking to be relieved of liability is engaged in a business of a type generally thought suitable for public regulation. 4. The exculpatory clause attempts to excuse liability for gross negligence, willful misconduct, or intentional torts. In the context of a real estate broker's duties to a purchaser, there are certain standards of care and legal obligations that are considered important for consumer protection. An exculpatory clause that attempts to completely shield the broker from liability for their own negligence in fulfilling these duties could be seen as undermining these protections and therefore against public policy. Question 534. A real estate agent is required to choose the kind of agency relationship she is working under. A. Before the close of escrow, B. when escrow is opened, C. as soon as practical, D. when either the buyer or seller asks the agent. Correct answer is C. as soon as practical. Waiting until the end of the transaction to disclose agency is far too late and would violate the agent's duty of disclosure. By this point, decisions have been made based on the presumed representation. While opening escrow is a significant step in the transaction, agency disclosure should occur much earlier. While an agent should certainly disclose their agency upon request, they are proactively required to disclose it even before being asked, at the earliest practical opportunity. Waiting for a question puts the onus on the client to understand agency relationships. Therefore, the requirement is for the agent to disclose their agency relationship as soon as practical in their dealings with potential buyers and sellers. Real estate agents have a legal and ethical obligation to disclose their agency relationship to all parties in a transaction as soon as practical. This means at the earliest possible opportunity when substantive contact is made with a potential buyer or seller. The goal is to ensure transparency and avoid any misunderstandings about whom the agent represents. This ensures all parties are informed about who the agent represents from the outset. Question 535. The kind of lease that sets an initial rental rate, with periodic increases built in, is called an A. Step-up lease. B. Escalator lease. C. Acceleration lease. D. Periodic lease. Correct answer is A. Step-up lease. An escalator lease also involves rent increases. But these increases are usually tied to external factors, such as changes in the Consumer Price Index, CPI, or increases in the landlord's operating expenses. They are not fixed in advance like in a step-up lease. Acceleration lease is not a standard type of lease in real estate. Acceleration clause typically refers to a provision in a loan or lease that allows the lender or landlord to demand the entire remaining balance due if the borrower or tenant defaults. A periodic lease, e.g., month-to-month, has a set rental rate for each period, but it automatically renews for successive periods until either party gives notice of termination. It doesn't necessarily have pre-scheduled increases built into the agreement. Step-up lease specifies an initial rental rate that will increase at predetermined intervals and by set amounts throughout the lease term. These increases are built into the lease agreement from the beginning.